All right, let's dive in. We're tackling what seems like a pretty simple question today. What is administrative law? Now, I know it sounds a little dry, but trust me on this, because how we answer this question gets right to the very heart of the relationship between you, the citizen, and the power of the state. You see, this is not something you can just get a quick dictionary definition for. It's a real puzzle, a head-scratcher, that has challenged some of the sharpest legal minds for more than 100 years. And why? Well, because defining it means we have to define the limits of government power itself. So we're going to frame this as a kind of battle of ideas. Think of it like a showdown. We're going to explore four totally different philosophies from four legal heavyweights, and each one is going to give us a unique lens to understand how we define, and more importantly, how we control the whole machinery of modern government. First up is our architect, Sir Ivor Jennings. He looked at administrative law and saw, well, basically a blueprint, the organizational chart that lays out the entire structure of government. What's so interesting about Jennings' view is just how straightforward it is. For him, it's all about the nuts and bolts. It's the who and the what of government. Who has the power, and what are they officially supposed to be doing with it? So let's break that blueprint down a little. Jennings saw three core parts. First, the organization, who reports to whom. Second, the powers. What is each department legally even allowed to do? And third, the duties. What are their specific jobs? It's a really clean, logical map of the government machine. But is a map really enough? Turns out that blueprint has some problems. Critics argue it's just way too broad. It doesn't draw a clear line between administrative law and, say, constitutional law. And maybe the biggest issue, it tells us all about the machine's parts, but it tells us absolutely nothing about how that machine actually runs. It completely misses the procedures, the real rules of the game. Okay, so if Jennings built the structure, our next thinker, A.V. Dicey, was the great skeptic. He was deeply, deeply suspicious of giving that structure any kind of special power. In fact, he was so suspicious, he initially said that administrative law didn't even exist in England. Dicey's entire philosophy was built on this one incredibly powerful idea, the rule of law. To him, this meant that everybody, from the person delivering your mail all the way up to the prime minister, should be judged by the exact same laws in the exact same courts as you or me. No special treatment and definitely no special government courts. So for Dicey, administrative law wasn't about government structure at all, not even close. It was about one thing, and one thing only: official liability. It was a tool purely for holding public officials accountable in a regular court of law. End of story. But you can probably see the problem here, right? Today, Dicey's view is seen as way too restrictive. I mean, the modern state is just so complex. It runs huge public corporations, and it needs what's called discretionary power just to function. Dicey saw any kind of discretion as a threat to liberty, and that's a view that just can't handle the reality of a 21st century government. All right, let's meet our next thinkers, Wade and Forsyth. I like to call them the watchdogs. They looked at the growing power of the state and argued that the real job of administrative law isn't to describe government, but to control it. Just listen to this definition. It's so powerful because it's so simple. This is a radical shift in thinking. The focus moves away from just describing the structure and moves directly to one single crucial word: control. Its entire purpose is to protect citizens from government overreach. And this slide right here, this is the key aha moment. It illustrates the difference perfectly. Jennings was asking, what is the government? But Wade and Forsyth, they asked a much sharper, more pointed question. How do we stop the government from abusing its power? This is often called the red light theory, and it's a perfect metaphor. Think of administrative law as a stoplight for the state. Its primary job is to slam on the brakes, to stop government action, to make sure it stays within its legal lanes and protects our fundamental rights. Okay, now we're going to pivot and hop across the pond to an American perspective with Kenneth Davis. He was our pragmatist. Davis wasn't really interested in these grand abstract theories. He wanted to know what government agencies were actually doing day to day and how the law could manage that. You can just hear the practicality in his definition, can't you? It's not about the whole of government. No, it's about the specific agencies, the doers, the ones that create the regulations and make the decisions that actually affect our lives. So Davis really zoomed in on the operational reality. He focused on the powers and procedures of the agencies that directly impact you and me. And he explicitly included the role of the courts in checking their actions, while pretty much ignoring things like internal office management. But here's the pushback. Is that focus maybe a little too narrow? By concentrating so intensely on just the agencies and the courts, Davis's approach can kind of overlook other really important forms of control, like the oversight that comes from Parliament or other legislative bodies. So we've been on quite a journey, right? We've seen the blueprint, the skeptic, the watchdog, and the pragmatist. So why does any of this matter? Let's try to pull all these different threads together. This table, I think, lays it all out beautifully. You've got Jennings' blueprint, which is all about structure. Dicey's skepticism, focused on liability. Wade and Forsyth, the watchdogs, zeroed in on control. And then Davis, the pragmatist, focusing on how agencies actually function. 4 totally different lenses on the same complex machine. Which, of course, brings us to the ultimate question we've been building towards this whole time. After hearing from all 4 of these brilliant minds, who actually got it right? And the answer is, they all did. These aren't really competing definitions. They're more like complementary perspectives. Each one reveals a vital piece of the puzzle. Administrative law is about structure, and it's about liability, and it's about control, and it's about function. It's the entire ecosystem that manages that tense, constant balancing act between state power and our individual freedom. And this powerful quote from Wade and Forsyth just pictures perfectly why this whole field is so incredibly important. As the role of the state in our lives grows, and it inevitably takes away some little bit of individual liberty, the mechanisms for justice, for control, and accountability have to grow even stronger to make up for it. And that leaves us with one final thought to chew on. In an age of just incredible technological and social change, the government's role is constantly evolving. So the real question for us now is, what will the next definition of its power and its limits look like?